Okay, give me 1 second, Luciana. Ah, that's why. Oops. Okay. Can you see him now? If you want to try. Gosh. Okay, so now you should be able to see them. The materials are all posted to the Twin page if you guys want to grab them. We're not going to do like go through essays tonight, but I'm just going to use some as examples. But I also have a handout. I also have a handout. Okay, thank you. It's not going to go past 8. I imagine it'll be like, we'll be done by like 7:30, Adam? Yeah, no worries. All right. Make sure you get those materials opened up. Okay, cool. Got it. All right, so let's go ahead and get started. So, yeah, no worries. Sorry about that. I'm the worst with Twin and doing that stuff, so that's definitely my fault. All right, so we're going to talk about worst case scenarios tonight. Let me get this back. Sharing. Okay. Um, so this is just like stuff that I've heard, stuff that I've read, stuff that students come to. Well, not just me. A lot of us with people that work in bar prep. So tonight the goals. We want to have a plan in case you panic. I don't know if you guys have ever had that on an essay, but if you do panic, we're going to talk about that. We're going to talk about what do you do when you have no idea for an MBE question. Have a plan in case you can't figure out an essay, and then have a plan in case you don't know what to do on a PT. So that's what we're going to go through tonight. Um, so, and then also just some of these scenarios, because I feel like this stuff has come up and it's not widely talked about. So first of all, a couple of things. When you are taking the bar exam, it's your exam. It's your exam. You 100% have the right to be a bit selfish, and I encourage you to be. I mean, not disruptive to other people or anything like that, but if something is bothering you, you need to address it. If it's something that is, somebody annoying is sitting next to you, they keep moving or they keep like shaking their leg or something, um, that can be really obnoxious. If a proctor is annoying, if they are talking, um, if they're talking, doing anything like that, you have a right to be moved. So you can just ask them, yeah, like somebody tapping their foot loudly or like shaking a table. That stuff drives me nuts. And if somebody is doing that, you have a right to be moved. And you don't necessarily have to do it right then. You don't have to do it right then, but you should absolutely ask to be moved. You can ask if it happens in the morning, you can tell them, and then in the afternoon they can move you. So there's that. If a proctor is being irritating, if they're talking, you can let another proctor know, or you can tell them. It's not the time, to be shy about that stuff. So just know that. What do you do if your car breaks down? So first of all, I would try to not drive on the day of the exam. For those of you taking it in San Diego, traffic can be a little bit of a no worries, Andrea. Traffic can be a little bit of a nightmare. If your car breaks down, then you don't want to worry about that. So I would try to take some other car, or try to take some other mode of transportation, take a Lyft, take an Uber, anything like that. Um, Also, just have if you're gonna park, make sure you know where you're gonna go. Make sure there's like not anything that's gonna get in the way of that. So you want to think about these things. Um, I had not this bar cycle, but a couple bar cycles ago, I had a bunch of people get food poisoning the day before. Like a lot of people ate something bad, and they literally were like sick during the exam. So my advice for that is just to eat something really mellow. Eat something very bland, which not exciting. But I probably wouldn't go and get like a giant burrito with a bunch of salsa the night before the exam or at lunch or anything like that. So try to avoid it. Avoid anything like that. Avoid anything that might make you feel that way. Eat stuff that's going to be fine. You don't really want to drink a ton of water or a ton of coffee. You don't want to be having to get up to use the restroom during the exam a whole bunch or be like thinking about that. Um, so just try to avoid all of that. So, have a nice, some rice and chicken or whatever that's kind of mellow for dinner. Also don't suggest at lunch eating like a huge lunch, just because it can kind of make you sleepy. You get that like mid-afternoon slump, that a lot of people get. So you don't want that during the bar exam. Um, so be careful about that. Point five there, if your computer stops working. So what do you do if that happens? You need to get a blue book immediately. You need to get a blue book immediately. And if a proctor doesn't see you, like wave your arms in the air. You've got to get their attention. If they're not paying attention, they should be. There's a lot of proctors, walking around, and like there are literally eyes on every single person in the exam room. I just came back from a conference where um, the bar examiners talk about that because they talked about cheating, which just don't do it. But they do talk about it, and they were saying that when they're assigning proctors, there are literally supposed to be people, eyes on every single person. So they should be able to see you, but if they don't, like if your computer breaks, just like put your arm in the air and like wave it around and make some motion if you need to. Um, okay. Um, all right. So any questions about that? Just, don't be polite, eat well, don't drink too much coffee, and you're good. All right. All right. So what do you do if you panic? So this is on that first page of the worksheet that I gave you. Let me see. Let me do this. Actually, let me. Oops. Sorry, guys. Um, okay, so if you panic, right, and like this happens, like I definitely experienced this a little bit on my exam. Um, so I saw the very first essay, and it was something that I wasn't expecting. Um, so it threw me off, and I was definitely like couldn't think, and I paused for a minute, and that's not a very exciting way to start the exam. So check, if you're holding your breath, like, and the reason that panic is so bad on an exam is, A, it takes time, and then it makes it worse because you're like, shoot, I'm losing time. But B, the other part of it that's bad is that it affects your frontal cortex, which is, I think it's a frontal cortex. But that's where your memory pulls from. So like if you are panicking, then it's literally going to interrupt your ability to recall, which is like you need to recall the rules. So that's the process that it interferes with. So stop for a second. Notice if you're holding your breath. Like unclench your jaw. It's like I see these on Instagram when I'm like going through my Instagram feed, and it'll say, "All right, stop. Like take a breath, unlock your shoulders, and um, just totally relax." So you want to do that. You want to try to remember to do that in that moment. It's good to take a break for a minute and just walk away for a second. And it's sort of because you can kind of distract yourself a little bit, which is a good thing. So take a little break, get up and get some water, splash some water in your face, just drink some water. Um, and I say to have like a positive thought ready. So something you're looking forward to. So I want you guys to take a minute on that handout and write out, I put a spot there. So write out a positive thought. So mine for the bar exam was Um, God, I have a few, but mine was, I was something that I was looking forward to. I was like, you know what? In 4 days, I was going to be in Hawaii. So it can be that, or like, I remember the day I got my dog, and that was really exciting. So I want you guys to take a couple minutes and write that down right now. Yeah, Adam, write your own positive thought. Write one that's your own. So something that makes you happy. Yeah, but you could also you could think about dogs in Hawaii too. All right, did you write one down? Adam, what did you write? Did you write about dogs in Hawaii, Adam? Good. Hi, Sarah. So you guys can share if you want. You don't have to. But just like even even right now, like if you think about it, like it probably does help you relax a little bit, right? And so like that's, I mean, at least for me, it makes you smile, and then that releases some endorphins, and it distracts you for a minute, and then you can figure out what's going on with what's in front of you. So it's good to take that mental break, even if it's yeah, there you go, traveling cross country, not having to study again. Yeah, good. That is a very good one. Um, all right. So that's, what do you do if you're panicking? That's what I want you guys to do, is go to that place, go to that thought. Okay. Um, once you do, once you do regain your composure, what do you do? Um, so once you regain composure, you want to review the question. I have my notes down here. Oops. You want to review the question. Um, sorry, let me go back. Um, sorry, guys. I'm trying to get this percentage review. You want to review the question. So go back, review the question, and start with what you know. So identify the area of law. Identify the area of law. So this is where having your issue checklist comes into play. So if you start with what you know and say, okay, well, I know I'm in torts. Okay, what are all the things that it could possibly be in torts? Negligence, intentional torts, all of these things. Negligence, intentional torts, defamation, privacy, like any of those. You just start writing that down, and then things will, hopefully you'll start to click a little bit. If you don't know, if you can't figure out what it is, then just start writing down the subjects, the big subject areas. Write down torts. Okay, could this be a tort issue? Could this be a contract issue? Could this be remedies? Could this be civil procedure? And even if you're not sure, other people probably aren't either. And this happened a couple of years ago in July 17, when people couldn't tell if it was a PR evidence or PR Civ Pro. And so many people were panicked about it, and which understandably so. Um, understandably so, but it didn't matter which way the people answered it at all. Like, it didn't matter at all. You could answer it as evidence, you could answer it as Civ Pro. So just know that too. Like, if you can't figure it out, other people are struggling. And if you can't figure it out and everybody's struggling, all you have to do well is maintain your composure and write something coherent. That's where you see essays that are sort of like, when you read them, like I will read them, and I'm just sort of floored at like how the selected answer, which is supposed to be one of the better answers, is kind of atrocious. I mean, that's because it was just hard for everyone. And when that's the case, that will help you. So you got to remember just to work at it and figure it out. So start with the law, identify the area of law, see if that assists with the recall, then focus on general rules. So see if you can provide some sort of clear general rule, and then see if you can recall more specific rules so you can build a paragraph if needed. You want to think very deliberately and respond accordingly. So reread the call of the question, process through the fact pattern again. And things should really look familiar to you guys. In these last couple of weeks, it is a good idea to, like at night, like, after you've done your active practice, you've done everything your bar company has assigned you, you've done your, 33 to 50 MBEs every day, you've done X number of PTs. After you've done all of that, at the end of the day, I think it's a good idea just to read some bar fact patterns and read responses. It doesn't necessarily have to be the ones that your bar company gave you. You can just get them off the CalBar website and look at them, because it's just getting that exposure and seeing, how different issues are triggered by different sets of facts can be helpful. So I think it's not the most thrilling thing. It might help you just sleep, if anything. But it's a good idea. So you guys want to be this third person here, not one of the three with their hair on fire. Okay, just don't do this. That stuff does happen. Like, people do have, um, yeah, people, yeah, Andrea, yeah, people that it happens. My business partner, he was sitting next to someone, um, and the guy literally, like, during the MBE portion, but just like kind of stabbed his pencils into the paper and just like shredded the page, because he just didn't like the question. So, which, he was having a little bit of a mild issue there, but don't let it distract you either. If someone is like, there was another student, she passed last time, but um, the person next to her just like wasn't writing anything during the written day, and it was freaking her out because she's like, this person's just sitting there the entire time, like wasn't writing. Um, that doesn't matter. Like, don't worry about anybody else. This is also why it's a good idea. This is why it's also a good idea to, oh, what was I going to say? Oh, earplugs. Make sure you bring earplugs and bring extras. Like, I stuck 2 pairs in my ears, and I think I've told everybody this probably numerous times, but when I took the LSAT, there was a person in front of me, um, who had like exercised and not worn deodorant, and or maybe he was just nervous, but he smelled so, it was just like the worst BO I'd ever smelled, and it was really distracting. Like, honestly, it was really distracting. And I actually retook the LSAT because of that, because I did not score near, and like I was just distracted the entire time. Um, so I say to bring an extra pair, just so that you can stick them up your nose. Um, Sorry, Andrea. Sarah, no, you cannot wear hats. You can't wear hats. You can't even have headbands on. Um, you can't have. So what I did though was like I put one of those, like a running one, like a fleece running one, around my head. Yeah, unless it's a religious necessity. That is correct, Andrea. But yeah, like regular hats, no. Yeah, Luciano, I'll get to making up rules. All right. That being said, too, if the San Diego Test Center, I think, tends to be cold from what I recall. So you should wear layers. Everybody should just wear layers so that you can be comfortable. And you should obviously all like by now, or at least, no later than Sunday, print your ticket, your admission ticket. Make sure you print that. You go over the rules of what you can and can't have, and put your baggie together with everything. All right. So worst case scenario, writing. There you go. So if you forget the rule of law. So this is, the reason I have this is, or I'm sorry, making up a rule. So if you forget the rule of law, so what I want you to do right now, I want you to write these down. So this is the formula for rules. If you look at the Word document that I have on the left side of the screen here. So I have in blue, I have like what is, what somebody will be convicted of, or a defendant commits X when. So this is like who can do something. So a defendant is liable for or commits or may do, um, and then a crime, a tort, or whatever legal issue when elements or factors. So I have a defendant is liable for murder when he kills another person with malice aforethought. An attorney may permissively withdraw when it would not harm the client, the attorney can demonstrate a cause, or the representation will financially burden the attorney. So now I want you guys, all right, so that is the formula. So what I want you to do is, when you are in a particular, if you can't remember a rule of law, I want you to think, okay, well, what subject is this in? And I want you to like think about policy and like big picture rules of law. So look at breach, look at jurisdiction, look at reasonableness, good faith, duty, justice, fairness, judicial economy, all of those things that are big principles in in developing rules of law. Why do we have certain laws? Um, so that's really like that's step one is is there something do we want people to act reasonably, or is this a fairness issue? So go to those concepts. um, you can also break up the fact pattern into parts that are common to every case and proceed from there. So you can look at the parties and the nature of their relationship, like employer and employee. And when I see that, I think about the disparity in the bargaining power between the two. I think of the landlord and the tenant, and then I start thinking of, okay, well, we want to promote that, but we don't want we don't like slumlords. We want tenants to be able to live somewhere comfortably, et cetera. I think, okay, well, landlord tenant still has certain rights. What rights do they have? And then the relationship between a buyer and a seller. Also there's places. So is it a public area? Is it a private home? Is it a farm? So that makes me think of criminal procedure. That I'm in criminal procedure, and I'm like, okay, so if it's public, you probably don't have an expectation of privacy. If it's private, you definitely do have an expectation of farm. Is you're probably not expecting a whole lot of people, and then I think about the curtilage, etc. Are there any objects involved? So is it a sale of goods, or is it land or a chattel in dispute, or a particular defense? You can also characterize the relief sought. So you can characterize relief. So what kind of relief? Is it legal? Is it monetary? Is it equitable? Is it is it a legal or an equitable one? Are they asking for specific performance? What is the thing being sought? Um, oops. Okay. So what I want you to do right now is I want you to go to that Word document where it says make up a rule. And I want you to just, unless you know it, but I doubt it, most people don't know these when I give them to them, is abusive process. So I want you to just make up a rule and use this formula that's right above. So what are you going to start with for the first one? Are you guys writing them out? Okay, good. And then when you're done with abusive process, do malicious prosecution. And just tell me when you're done. Does anybody need more time? Okay. All right. So what did you get? So the rule is, so there's two elements. So you have to have an ulterior purpose or motive underlying the use of process, and an act that is not proper in the regular prosecution of proceedings. That's it. So it's like if you just look at it, if you just even look at the issues, abuse of process, so that's abuse means something wrong, wrongful use of process. That's basically it. So you could just write something like that. You could say a defendant commits abuse of process when he improperly used the court system, something like that, and you would be pretty good. And then malicious prosecution. So malicious prosecution, it requires yeah, let's see. Yeah, that's really good. That's really good. That's great. If you guys want to paste yours in, I'm happy to look at them. But that's awesome. Yeah, good job. And then what about malicious prosecution? Anybody got that? You won. Luciana, is it Luciana or Luciana with a CH? I feel like I'm probably saying it wrong. So Luciana? I don't get it. Sorry, I'll figure that out later. Sorry. Um, all right. So, um, good job. So one of the reasons that I like people to do that is because well, not one of, like really one of the main reasons is because part of the process of studying for the bar is getting really uncomfortable or getting really comfortable doing things that are uncomfortable. I think that's a very important part of this process. Um, and it's something that it's difficult. So like, doing a ton of essays and doing them blind, like not knowing what subject you're getting. So not knowing what subject you're getting is in practice, so that because that's how it is on the real day. Um, good. Yeah, nice job, Maria. That's really good too. Um, so you want to just put yourself in that scenario as much as possible. So like when you have to make up a rule, when you're forced to do it, and then that way when you do it and you find out that you did it okay, like like we just saw here, then that is going to give you a sense of comfort on the bar exam when you're like, oh God, okay, well every time I had to do that, I did a pretty good job. So that's the goal. That's the goal. All right. So and then if you look down at this is, I made a list for each subject. So BA, Civ Pro, Community Property, and obviously you guys have this, but it just lists a lot of the policy and it lists basically a list A. So this is your list, this is a list that I made. So like when I am writing, when I'm doing a bar essay and, I read the call, then I make my list A if I can, or else I start looking at the facts until I can make my list A, and figure out what subject I'm in. I make this list here to sort of go back to start running through if I can't figure out what issues, and I start running through these issue checklists. So I gave you sort of some big, I gave you some of the big policy and then my list A, and you would probably want to expand this or modify it. So here's for every subject for each of you or for you so that you can use this. But I would, if I were you guys, I would also over the next couple of weeks, a really good idea is to take this list and see how much you can expand upon it just from memory. So, I say take like 3 subjects a day, and this shouldn't be a long thing. And you totally don't have to do this. You totally don't have to do this. But what I would say is, take this like authority. Okay, well, agency authority. So what are the different types? Actual, apparent, actual. So express. It could be either express or implied, and then you have actual, apparent, or else you don't have authority. So then, okay, well, do you know the rules for those? And partnership. Okay, how do you form a partnership? When you have a partnership, what are each partner's liabilities, and what are the limits on that liability? If one partner commits a tort or a fraud or something like that. Then corporation, okay, the formation, what happens when it fails? the two different types, the fiduciary duties, what are all the fundamental corporate changes, what a 10b5 and a 16b securities transaction, what are the factors when considering to pierce a corporate veil. So, and seeing if you can, okay, so if I look at securities and I'm like, all right, 10b5, then, can I list out all the elements for 10b5 and do I know them? Or 16b, that's where the like swing profits, if you buy or sell, buy within a 6-month period of, and you own a certain number of shares, it's that issue with securities. So go through and just try to expand these out as much as possible. And it's just good to force yourself to recall, force yourself to do that recall. All right, so that's what this is for. So I don't think we'll use this the rest of the evening, but that's something you can save or print or whatever. All right, so let me go back to my slides. Okay. All right. That's good. So another thing when you're writing, if you can't figure out how to organize it, and this is a big issue, a lot of people struggle with this, even on the real day. You organize by law and the subjects on the left, so con law, property, generally speaking, criminal law, contracts, like all the big picture ideas. So contracts are going to run through, what is the governing law? Okay, has a contract been formed? What are the terms of the contract? Is performance done? Has there been a breach? You're going to go through all of those. Your big headings are going to be by law. You're going to have legal issue headings, and you might have factual headings below that. So, if you're going through a contract formation essay, and then so you're going through offer, and under offer, you might do, the May 1st communication, the May 10th fax, the May 15th phone call. You probably will have factual headings like that too. And then where you're organizing by thing, so I say thing, this might be like a piece of evidence. So in evidence, so first it's going to say, the email, and below that you list all of your legal issues. And then the next big heading would be, Dan's statement, and then list all the headings below that. So by thing, criminal procedure, you're also going by piece of evidence, the bag of cocaine, the gun. So those are things you're going to organize by. Also in wills and trusts, this one actually is kind of a mix. You might go by thing or by person, but oftentimes you're going to go, you actually will have probably a mix of the two. So you'll talk about, was there a valid will, has been revoked, et cetera. And then you're probably going to go, okay, distribution, and distribute to, A, B, and C. Community property is often, it's most frequently, community property is really by thing. You talk about the distribution, you talk about each property and its characterization, how it was acquired, et cetera. And then contracts, I list that because sometimes if you can't figure out, just go chronologically and go through each communication and like, what are the legal issues? You can go that way too. Any questions about that, or any question about anything so far? Okay, cool. All right, so running out of time. So what do you do if you're running out of time? I'd say this is probably the most difficult with the afternoon session on day one, but you want to be really strategic. So the amount of time that you need to spend, first of all, obviously, is don't try to save time on any particular essay. So like I know someone, she wants to, she's like, oh, well, can I try to like shave off, 5 minutes of each essay? That way I have 10 minutes extra on my PT. No, like unless you are absolutely done, I don't want anybody doing that. So use a time allocated. But if you're running out of time, so hit the main issues. So if it looks like there's a battery, let's see, or no. So if it looks like there's an assault, and you can talk the facts trigger, but you know that the defendant's not going to be liable for assault, then if you know they're not going to be liable for assault, then just get to the element why. So say they're not liable because there was no actual apprehension, but the defendant did intend to do it. All the other elements are met, but there was no apprehension. For your analysis, you just put out an assault heading. Say here, defendant did not commit assault because plaintiff did not see when he jumped out and tried to scare her. And that's it. And then give a conclusion and you're good, instead of laying out the rule and the analysis and the conclusion in different paragraphs. So just hit the main issue to demonstrate why a particular claim fails. One student always said, like, when in doubt, headline it out. And I'm totally for that. Headings are your best friend. Definitely omit some rules. Focus on the analysis and the facts, because your analysis should have the buzzwords tied in already. They should have them tied in already. So that is how you can demonstrate your knowledge of what the rules are. So you can go ahead and omit some rules, or you can, yeah, just do that. All right. So for PR, you've got to hit the duties. Make sure that you are up on the updates to the rules. There's a good article written by a LA County Superior Court judge. But remember, and she kind of just goes through and outlines the changes, and it's pretty easy to read. But the big ones is in California, the lawyer, they changed the rules on having sex with a client. So that's a change now. They also they got stricter with the financial rules, where the retainer has to be a true retainer. So you want to just, make sure you're up to date on the changes. They also made the duty of loyalty more in conformity with the ABA rules. So just make sure you know that stuff. Make sure you know that stuff. A bunch of people are going to forget it on the real thing, I think. But just know this. So the mnemonic is clients love fierce counsel. Courts feel differently is the mnemonic. So, and it has the first four are duties owed to the client, and the second, or the last three are duties to the public and to the court and fairness. So clients love fierce counsel, courts feel differently. So just, if you remember that, that covers a lot of PR. Some of the lesser known duties, I list them here, that you can often, I think competence is on the first one. No, yeah. Competence is both times. It's not a lesser known duty. But you have duty to uphold the law, duty to state the law truthfully, decorum, impartiality of the tribunal, diligence, etc. So these are some of the lesser known duties: duty to expedite a case, duty to communicate. I always think too, like, there's a duty to withdraw if there's been a violation. You might have a duty to withdraw. So yeah, so these are extra things that you can throw in there. Okay. So let's see. Hold on one second. Okay. All right. So worst case scenario with the PT. I just don't think this is very likely, but I want you to be ready for it. So, what happens if you're not familiar with the task you have to perform, if you have no idea what the statutes are dealing with, if it looks like your client might be wrong or lose something, if you're totally running out of time, what do you do if there will be case law, but there might not be case law on point for what you're looking for, or if there's no statutes. So first out, you always want to outline the task memo. So look for any instructions, see if there's any format, like a format memo, or an in-house memorandum. You also, if they tell you, if you're not familiar with the task you have to perform, you want to look for examples. So there is one that I gave recently that had, a full memo, but it also had the students draft an arbitration clause. And within the cases, there were like 4 or 5 different arbitration clauses. Plus we had the firm's standard arbitration clause. So when you're told to draft something, even if they don't tell you what it normally looks like, look for examples within the library. There will often be there. So look for that. And we're going to see one of these in a little bit. So what if you do if you don't understand the statutes? I don't blame you. Oftentimes statutes are written horribly. If it doesn't make sense, then you want to go to the case law, and especially if there are a lot of statutes, then you want to go to the case law and you want to see, okay, well, which statutes are discussed the most, because that's going to tell you the ones that you really need to focus on, and it will help you understand what the meaning of the statutes. The third point there, if it looks like your client might be wrong or lose an issue, it's totally okay. In practice, like that is what happens. Sometimes you have to give your client bad news. And the bar examiners want to see your judgment in the performance test. They want to see that you are Um, they want to see that you can, deliver some bad news and properly advise about that. Um, so you definitely want to think about that, and it's okay. Generally speaking, though, your client overall will win. So that's something to keep in mind. If you find that your client's just like losing everything terribly, that's really unlikely. I've not seen that happen. Generally, your client is going to win. Um, so just know that, but also like don't be overly aggressive, and that this is really the mistake that I see more is people get overly aggressive, and you need to be objective and you need to identify counter arguments, and if you need to concede a point, that's completely fine. It's completely fine to do, so make sure that you do that, if it's called for. um, so if there's no case law on point, you're probably going to have a statute on point, and that's okay. And that just means you don't have to do a lot of analogizing. You just apply the law straight to the facts. You often will not have statutes. I think that's totally fine. Um, so know that, that's okay. And just know too that you will have a file in a library. You will have both of those things. Um, I just had someone, her library got like stuck to the inside of the envelope on the last bar. Um, and so she thought that there wasn't a library, and that's not the case. There definitely was one. And uh, there definitely was one. Hers was just stuck to the inside of her packet, but she like didn't realize that until she only had like 15 minutes left. So just make sure you've got all your materials. Okay, so on the fourth point there, if you're running out of time, so make sure that you plan out your answer. Sarah asked, yeah, you are allowed to rip the PT apart, absolutely. And I would always rip out that task memo and put it in front of you. Get one of those little paper holder stands. Get one of those, and I think that helps. I put my materials that I'm working with there. Yeah, no worries. So pre-write. So make sure you organize your thoughts, and this is true with everything. You've got to organize your thought first. Your thoughts. Figure out. As soon as you identify what type of a document it is, you want to do your setup. If it's a letter, do your setup like a letter. If it's a memo, do your setup like a memo. If it's a brief, go put in those components. If it tells you to put in a statement of facts, and put your heading for statement of facts. And I use Roman numerals. So you want to get that set up. Then the next task is figuring out, okay, well, what are your headings in your analysis or in your argument section? So you're looking to identify that. So outline those things, and you want to do that generally speaking on paper, so that you can kind of get your thoughts, identify where do the cases fit in. So organize, and even if everybody else is jumping in, or you see people when they start typing, it gives them a sense of security, but it doesn't mean they're going to finish it faster. So just because someone started earlier than you doesn't mean that they're doing better. Oftentimes people get comfort from, especially like on the essays, like they'll just start typing, and I don't know what they're typing. But you've got to spend that time going through and planning out your answer and thinking through. That way you spend, the entire time that you're supposed to be writing, actually writing, and not pausing to stop and think, because people don't keep track of how much time they lose that way, and it tends to be substantial. So the PT. So, all right. So the second packet that was posted, the PDF, has had a few essays in it. So we're going to skip over those for right now. We're going to skip over those. And then I want you to go to page 5, this file of In Re Emily Dunn. So I want you to take a few minutes, and there's a page missing in here, and that's okay. So if you go to this page with the task memo, I want you to take 5 minutes to read it and outline it. Are you guys done, or do you need another minute? Okay. Anybody else done? You still work? Need a minute? Okay, good. All right. So how was that? Terrifying? A little scary? You all good about that? So weird. Horrific, right? Okay, good. I mean, not good, but that's what I expect. But so they tell you to draft a will, right? Which is mildly terrifying. And then they give you this, but they do give you on the next page. They give you will drafting instructions. So they give you guidelines. So they give you guidelines, which is really helpful in theory. They also give you, if you scroll through this, they also give you on page 10 here. They give you a sample of what it looks like. So now I'm just going to go copy that. Like that's literally all you would do. And so many people are going to spend so much time panicking. They're not even going to figure out just to copy this. You're obviously going to modify it, make some changes, but you've got some stuff here that's going to help you. So did you guys all see all this or did you just look at the task memo? Yeah. Yeah, so did you feel better though once you saw, you're like, all right, I've got some guidelines and I have a sample here? Good. Yeah. So I mean, if they give you something weird, they're gonna help you out. They're gonna help you out. So I wouldn't worry too much about getting something crazy like this. But if they do, just look for this stuff. The answer is in there. And also, know that if they give you something really weird, everybody's gonna be freaking out. And I tell everybody my friend, when a friend of mine was taking the bar. She literally, like most people, couldn't answer. There were two calls, and the second call had five questions, and nobody could answer the second call. Like she's like incredibly brilliant, and walked out of the exam room crying. Most people were at the exam center in LA, so huge. Um, but it was just atrocious because people couldn't figure it out. And that one definitely like brought me to tears too. And um, but it didn't matter. She didn't answer the second, like literally the five call question, and she was fine. She still passed. It didn't have a big deal, or didn't have a big impact on her. So it'll be okay. All right. So that's kind of like worst case scenario for a PT. So now you've seen it. If you're out in California, Um, you should definitely go spend some time and look at all of the recently given PTs, the ones that were given in the last few years in California. Just so if you haven't done it, I think those are really good to do. All right, so now I'm done. We're done with the writing packet. I'm not going to actually go into essays tonight because we're doing so many in the next couple of days. So, all right. Let me go back to this. All right, so now we're going to talk about the MBEs. So let's go. Okay, so now we're going to talk about the MBE. So when you're going through them, you read the call of the question, identify, what subject you're in if it tells you the controversy. So you want to read it. You want to circle the relevant facts or what you think are relevant, and if you can identify that facts are distractors, I would line through those. Don't ever make any assumptions, and then you definitely want to, before you get to the answer options, if you think you know the answer, you want to try to predict it. Then when you get to the answers, you're hopefully the one that you predicted is there. Then you still want to go through and eliminate the other three. So make sure you're going through that. So eliminate any answer choice that mischaracterizes the facts. So if there's a blatant contradiction, if the fact pattern says that the light was green and the fact pattern says that the light was red, like that's a blatant fact contradiction. I don't see these too much, but they do come up. So it's something just to be aware of. If something goes beyond the facts or assumes as true a fact that's actually in dispute. So you want to look at language that might modify that. So, say if something, it says, if something says, guilty, or liable because the defendant acted negligently, or liable if the defendant acted negligently. So those two things are very different. So one is liable. One assumes a fact that it assumes that he does, when it's actually whether he acted negligently is in dispute. So you want to look for those. The next thing is you want to translate. So oftentimes, I think 20 to 30% or even more of MBE questions are missed because it's a reading comprehension issue. And I don't mean that in a derogatory way at all. The stuff is just written in a very tricky manner. The questions are hard. And sometimes you have to interpret the questions. So that's good to recharacterize questions as you're going through them now. So look at that. If it says, if the defendant wins, it will be because, and what that means actually is, what is the only basis upon which defendant could recover or defendant would win. All right, so you want to translate the call of the question. Or maybe you can even skip the call of the question. See what you can look at just the answer options and look at the clues as to what the NCBE thinks is the correct answer. So if you have 3 variations on one thing, then look at that and identify what are the distinctions between the answer options. And then, is the law correct but stated in an incorrect way? So if they're giving you one standard and they're essentially saying rational basis, but a word is off that makes it incorrect, like that's obviously incorrect. So try to just identify those things right off the bat. If you notice that, if it says that if it's strict scrutiny and it says that the plaintiff has to prove, well, the defendant or the government has to show that something meets strict scrutiny, not the plaintiff. So you want to look for stuff like that that's just blatantly incorrect. All right. And then if you know some law, so this is if you know it and you're like, oh, I think it's this, and that I'm sure happens on a lot of it. So can you identify half of a 2-part issue? So, if you have a removal questions, you have to consider timing and subject matter jurisdiction. So just when you're in the question, you really just want to try to narrow it as much as you can. So if you're in torts and you're in negligence and you're in duty and you're in Cardozo, and you can't remember, okay, well, what are the components of Cardozo? Or if you can't remember, or if you're in, what is the relevant standard of care? And you're like, all right, well, there's, you're like, I think there's there's RPP, but you're like, oh, there's specials, and you're not sure. Okay, well, what about the professional? Who all can that apply to? Try to just get as narrow as possible. So you want to look for that. If you also know that there's a rule of law that's not the majority, if you know that it's the minority and it's not telling you that there's, sometimes you'll see phrasing in the MBE questions that says something along the lines of, assume that the common law has not been modified. So that means you're under the old common law rule. So if you're under like old common law burglary, then you would apply all those old common law rules. But if you're in a modern jurisdiction, if it doesn't say that and it says, oh, they're not guilty because it wasn't nighttime, well, then that that's incorrect because you're in a modern jurisdiction that has eliminated it. So look at if you can cross something out just because it's outdated. So look at that. And then if you recognize that there is law and the answer is it the complete rule of law, which leads me to the next thing. So easiest to prove based on this law. So when the question asks you what is the defendant's best argument, what that really means is what is the easiest to prove based on this law and these facts. And just remember that it doesn't necessarily mean a good answer. Oftentimes the best answer is still a terrible answer, and that's okay. That's totally okay, and that's really common. More precise is better. And you want more precision as to the law and or the facts. So you really do want to look for you want to look for precision. So if there's more, if something is one thing kind of says something generally and another is specific, go for the more specific. All right. So if you have to guess, first eliminate any wrong answers you know are absolutely wrong. So everything that we've just talked about. So you shouldn't have any if or unless modifiers. So I'm actually not going to worry about that. Those have been eliminated. But you do want to be wary of absolutes. So obviously cross those out, gives you only or every or anything like that. If two answers are the complete opposite, one of those is probably correct. So look for that. So that's what you want to look for often. And that often is the case. If two answers look essentially the same, unless one is much more specific, it's incorrect. And just generally, like if you can't pick, go for the longer answer over the shorter one. That's kind of a fallback as well. All right. So the NCB has also greatly reduced the number of none of the above or hearsay not within any exception. So if you see those, you should think about why. It might actually be, more specific is correct. What do you mean? I'm sorry, I just saw this about the rules on page 45. I don't know what you're referring to. I'll go back and look at it. So the NCB has reduced the number of the none of the above or hearsay not within any exception. So ask yourself why. Like it might actually be the correct answer. And remember that, the people like in these, you have to sort of keep, people don't really matter. So a lot of times they'll make the bad guy win. Relationships don't necessarily matter, and you've got to focus really on duties. Like, is a duty owed? Or what's the relationship between these two people? And is there some sort of special relationship that creates some legal obligation? All right, and then these are just some subject specific that I did go over, I think, with when I did the workshops. But, if a question concerns the validity of a statute, first determine if the statute is a state or federal one. So if it's statutes, means if you have a statute, that means the answer is generally not equal protection. If the issue is equal protection, pick an answer that references the Fifth Amendment or the Due Process Clause. And if something asks about the general welfare, then that's just referring to taxing and spending, that there's can't just act for the general welfare. And I'm going to post all these so you guys don't have to worry about writing it down if you are right now. All right, so let's talk about contracts. So, if there is a contract, then you also know that the answer can't be the promissory estoppel or quasi-contract. You want to focus on the introductions. Is somebody retired? And as an example, if somebody is retired, they might not be a merchant unless they fall under that. There's a little narrow exception to that. So look at those details. You really want to pay attention to those details and the characterizations of people. And I think a lot, in particular in contracts questions. Criminal law. So examine the statute. So even if you're not sure what it means, what might the issue with it be? So identify the key words. And if it's a statute that's sort of something new, try to think of, okay, well, what does this sound like? If they give you a statute and it sounds sort of like larceny, then sort of give it a larceny analysis. So know that. If they say, if the jury believes him, then you do have to, they're telling you that the jury does believe him. The jury does believe him. And then if it's a criminal procedure question that's dealing with the Fourth Amendment, you want to categorize the type of search first. All right, and then evidence. These are just some wrong answer choice at the top here. So testimony is inadmissible due to its self-serving nature. So if something is self-serving, it goes to credibility, but it doesn't affect admissibility. So something wouldn't be inadmissible on that basis. So that's one thing. Make sure you have the concepts of bias and competence separated. So bias means competence is your ability to testify. So you're competent, you have personal knowledge, and you know the distinction, and that you understand what it means to take an oath, essentially. But bias is like, okay, well, somebody likes me, so they're going to testify in my favor. So that's bias. Like if I call my brother to testify, they're going to say, okay, well, if my brother gets called to the stand and I'm being prosecuted, the other side is going to, the state is going to definitely the other side is definitely going to point that out and let them know that, okay, well, this is your sister, right? Would you ever want to see your sister go to prison? No, all of those things. Or that's bias. And sometimes, and just don't assume that the answer that says inadmissible because it is hearsay, not within an exception, that is correct sometimes. It's absolutely correct sometimes. So make sure that you use that. And I always forget this. They use POE. And Andrea, I think you told me, I asked you this before. Oh, it's gonna escape me for a second. In evidence. What POE was for. Because I put this and I always know it when I write it and then I forget it. Is it like proof of, it'll come back. It'll come back to me. All right. And then real property. Remember that bona fide purchaser status only matters for subsequent purchasers. And in real property, you've got to beware of constitutional answers. Beware of them um, before you pick them. You wanna eliminate the property answers first. All right, so those are just some sort of general MBE tips. Those are some general MBE tips, and I will post these so you guys have them. Anybody have any questions? Okay. All right. Well, I'll see you guys the next couple of nights, regardless. Obviously, you have I don't know which one is tomorrow. It's either Wills and Trusts or BAPR, but I will make sure those are posted, and then kind of go from there. And I will see you guys tomorrow evening. Good luck. Keep it up. Yeah, just keep it up. Bye. Thank you. You're welcome.